everyone. Thank you so much for joining us today. I hope you're all staying warm in this winter weather that decided to come a bit early this year, in my opinion. All right, we're going to get started with a few housekeeping items. If you get disconnected for any reason, please log back in immediately and notify us about the interruption via email, just in case there's any issues on our end. If you're using the GoToWebinar app on your iPhone, please notify us and pay special attention to the number I will be providing in a moment. You may need to provide this number as well as the number I give at the end of the webinar for proof of attendance. At the time of registration, you were asked to provide the names of all those sitting in with you watching this webinar. Please let us know if there were any names you missed. In order to receive credit for this webinar, you must have been pre-registered through the NYS FDA portal and provided your name upon logging in. Following the webinar, we ask that you give us 7 to 10 business days for your portal to reflect the credit given, and you'll also receive a mailed certificate. If you have any questions during the webinar, please type them in the question box and we will answer them at the end. The number you need to know for the start of the webinar is 24. You see that on your screen, that's 24. At this time, I'd like to turn things over to our president, Michael Gorton.
Good afternoon, everyone. I'm Michael Gorton, president of New York State Funeral Directors Association. I just want to welcome you today to our webinar. Mike Lenati is going to jump on shortly, but I just want to give you some updates. What the board and the officers in the association has been working on. Last month, we went around the state and we performed the virtual town hall meetings throughout the 9 regions. Thank you all for those who attended them. One of the topics that we talked about was the new procedure that we're having for the legislative agenda. I'm happy to report that the results are in. You'll see more detailed information in our newsletter, but I figured I'd share them with you first of all. We did have over 30% of our membership participate, so that threshold was met. There were only 2 of the 4 items on the survey that moved forward to the committee, meaning that they received over 75% support from our member firms. The 2 that will be moving on are, number 1, giving the Bureau legal authority to investigate unregistered entities acting or representing themselves to be licensed. That received 96% support. The other question was in relation to the previous one, supporting legislation that would allow for the local DA to investigate reports of potential misconduct if the Bureau fails to act within 30 days of notice. This received 85% support. The other 2, amending the law to allow funeral firms to own and operate NOR facilities, received 42%, and support and changes to the food and beverage law to allow alcohol received 27% support. Remember that we needed 75% to pass it on to the Government Affairs Committee. You should have received by now an email from me, the association, regarding your membership renewals. You can begin them now, so do take a look at that email that came out. I believe it was yesterday or the day before. The newsletter will be coming out next week. There'll be chock full of information in that newsletter, so keep your eyes peeled for that. Next week, the officers will be up in Connecticut at the Water's Edge to meet with the 5 state partnerships. They consist of New York, New Jersey, Pennsylvania, Connecticut, and Massachusetts. We have 2 days of meetings, 2.5 days of meetings. We'll be going over some issues that each state face and how each of the states can all work together. So there's some more information will be coming forth after that meeting. And then following that, the first week of December, we have our association quarterly meetings. Again, a chock full slate of meetings from Bridge to past presidents to Tribute to FDSS, to the Government Affairs Committee, and to the big board. They all will be meeting during those couple of days up in Albany in the first week of December. So with that, like I said, keep your eyes out for the newsletter coming next week. If there's anything that you ever need from your association, from myself or from staff, please don't hesitate to reach out. We're here for you. At this time, I'm going to turn this over to Kelly or Mike.
You can turn it right over to Mike Lenati.
All right, so then I'm happy to introduce our Executive Director, Mr. Mike Linati, who will be addressing today's CEU program. Take it away, Mike.
Thank you, sir. Good afternoon, everybody. Welcome to the Final Disposition webinar. My guess, if you've been on this before, the good news is not a lot has changed. Hopefully, as we go through things, if it is something that you've been on before, or even if you haven't, hopefully this is stuff that seems very familiar to you. I will tell you that this is the area that we get the most compliance calls about, so we know it's always something that's on your mind. I think the real reason that happens is because of all the different scenarios that you guys are faced with when dealing with the family dynamic. So we'll be able to talk a little bit about that. I will save time for questions at the end because we tend to get a lot of questions when we do this webinar. So without further ado, let me get going and we'll work our way through the presentation. So this was a law that has been around, it's hard to believe, almost 20 years now. It started in 2006, and it has been amended 3 times. You can see there in 07, 12, and 22, and I will note some of those amendments as we walk through the presentation. The reason for this law, it really has 4 unique or distinct purposes. The first is it creates the priority list, or as we like to call it, the next of kin hierarchy. That is one of the things that we do, or we get a lot of calls about. So that's one of the reasons. The second is to create a process by which you could appoint an agent to control the disposition. Third are liability protections, and that's both for you as funeral directors for following direction, and also for the folks who are acting as agents so that they feel comfortable moving forward based on the wishes of the decedent. And then lastly, dispute resolution. While it doesn't talk about every possible scenario that a dispute will come up and how to resolve it, it does talk about dispute resolutions and some more protections and how to approach those things. So in reality, what it is it's a roadmap for funeral service, because prior to this law, funeral directors, having had to deal with the question of who controls a person's final disposition without any real direction. And increasingly, you guys found yourselves in the middle of disagreements or outright disputes amongst family members as to the method and procedures of their loved one's disposition. In addition, as you know, the landscape has been altered by the complexities and realities of today's society, which includes, for example, more non-traditional family structures. This factor presents emerging legal and practical challenges for funeral directors, who are also looked to by the decedent survivors to make the decision as to which of them has the legal authority to control their loved one's final disposition. However, as I know you all know, each situation is unique, and funeral directors are not always made aware of all the facts in a particular case. It's also extremely important to note that prior to this law, New York State did not provide funeral directors with any specific guidance on how to handle these situations or any explicit legal protections when doing so. As all of you know all too well, funeral directors are often put in the uncomfortable position of taking sides with one party over another, and by extension, seemingly endorsing a type of disposition that could ultimately be found to contravene the wishes of either the deceased or the loved one possessing legal control. Of course, things like cremation, which are irreversible, raise the stakes even higher. So needless to say, such a role goes well beyond what a funeral director acting in a kind of less risky, albeit important position of a mediator or arbiter. Unfortunately, these situations and circumstances cannot be avoided, but thanks to the final disposition law, funeral directors have heightened levels of clarity in dealing with family disputes, as well as significant liability protections that had been non-existent with our state law prior. One last note before we start walking through the statute. Please remember, this is a New York State law, so it only applies when someone dies in New York State. The only exception is when a person dies outside of New York, but has a valid agent form or a will, which would be deemed valid for disposition purposes under New York law, and where the disposition will take place in New York State. So generally, if you don't die in the state, you're not going to be following this law. There is that one exception that I just noted. And then one last disclaimer before we get going. Since we are reviewing a law and specifically a statute, and for those who don't know, I am a New York State licensed attorney, the words are very, very important. So I've included more content on slides than I normally would in a PowerPoint. And I'm also going to walk through the slides. They're going to go section by section the way the law is written. Sometimes that might not seem intuitive, but it's the way the law is put out there. So I'm just going to walk through it section by section. All right, so first, as most laws do, they deal with definitions. Now, this law does not contain very many defined terms at all. In fact, it only defines 3 terms: disposition, domestic partner, and person. So let's take a look at each of those definitions. So number 1, definition is defined as the care, disposal, transportation, burial, cremation, natural organic reduction, or embalming of the body. So all of those pieces are included in what this law refers to as disposition. Domestic partner is defined by 4 basically different ways you can create a domestic partnership in New York State. The first is you are formally a party to what's called a domestic partnership under either federal or state law. That is something that New York State does have and allows. Once you are entering into something like this, an actual partnership agreement, you would get a certificate as a domestic partner evidencing that you have a domestic partnership formed. So that would be the evidence of a domestic partnership. You can also register as a domestic partner of the person with an employer or any federal, state, or local municipality. In New York, it can be done at the state level. There is a state level registration. There are also registrations through most counties, including several cities and several towns. The larger cities are the ones that I found have the ones that most likely have a registration available for folks who are interested. Third is to be formally named as the beneficiary of or covered person under the other person's employment benefits or health insurance. Kind of a very straightforward, unique one, but that's one way to be a domestic partner. And the last one is the one that is the most common way of determining whether a domestic partnership exists. And that is what's called the totality of the circumstances test. So it's basically looking at all these different factors to determine whether this partnership exists. And none of them weigh more heavily than the other. Obviously, the more of them you have, the more likely it will be that you will be deemed a domestic partner. So what are some of the things that you would be looking for, or they'd have to show? It would be you own things together, a house, bank accounts, things of that nature, car. You have common householding, right? So what they're looking for is something more than we're roommates. So you're actually domiciling together, not just roommates. It's meant to be a relationship. You have shared income and shared expenses. So you pay the utility bills together, or you're having income coming in and it's jointly owned somehow. If you have kids together, that's obviously something that would factor in signs of intent to marry or become domestic partners. And obviously, the longer you've been sharing and creating a common household with one another, the longer that is, the more likely it is meant to be, or it will be viewed as a domestic partnership. Now, as a funeral director, you are not required under the law to obtain proof of a domestic partnership. So that said, however, when we get calls involving a dispute about someone claiming to be a domestic partner and other family members saying that they're not, if it's a dispute that's not clearly resolvable, we always make a recommendation to either ask the domestic partner to provide some information that would show that they truly were domestic partners. Some of the things listed here are things you can ask for. And that would be a good way, because that's a reasonable effort on your part. And if you don't feel comfortable at that point, then you'll hear me say this several times throughout the presentation, we would tell you to stop, pause, and tell all the parties that you can't proceed unless you have a court order directing you on how to move forward. This is one of the more complicated aspects of this law because and it's not even because of the law, it's because of the domestic partnership law and how you prove or disprove a domestic partnership in New York State. So the law tells us what a domestic partner can be. The law also tells us what a domestic partner cannot be. So no matter if you hit every one of those other tests or you the totality of the circumstances tests, it's not going to matter if you're related by blood or marriage, you're under 18, one of the parties or both are under 18 years old. If you're an adopted child of the other person, I know that sounds outlandish, but there are actual cases where these things have happened or tried to happen. Or if you're related by blood in a manner that would bar marriage in New York who a person is through the lawful spouse of another. So basically this like, there's an anti-incest law on the books in New York, and that last bullet is really just referencing that law so that you're preventing incest, marriage type incest aspects. The last defined term is person, and a person under this law is anyone who is 18 years old or older. And that's important because if you happen to be the mother or father of a deceased person and you want to have control and you happen to be 16 or 17 years old, you would not have control because you would not be a person under the law for purposes of controlling final disposition. All right, so the second section of the law deals with that priority list that I mentioned earlier. This is by far and away the most often referenced section of the law and the area we get the most compliance calls about. So let's walk through this. So what does the law say? It says that following people in descending order. So number 1 means number 1, number 10 means you're at the bottom of the list and the last one who's going to get asked. So descending order. These people listed have the right to control disposition. There was a change in 2022. That's the underlined italicized wording. That now states that if you have in certain situations, you can see there under number 3, 5, or 7, where you have more than 2 people in that same category, you need majority consent or approval of those people in order to move forward. If you have 2, this doesn't apply. If it's 3 or more, it applies. So you need 2 out of 3. If there's, say, 5 children, you need 3 out of 5. If there's 10 siblings, you need 6 out of 10. So on and so, like just basically simple majority. Okay, so knowing that you need that, and this is a descending order, what is the list? The first person on the list is the agent who filled out the agent form, or an agent if named in a will. Now, stating that you have a will with an executor named, and it says to pay my just funeral expenses, that is not enough for the will to serve as designating someone to be an agent. The language in the will must be substantially similar to the wording in the agent form for it to actually be an instrument that's designating a person under this hierarchy list. And we'll get into more of this a little later on. Second is if you don't have an agent, you go to the spouse. Per New York State law that changed in 2012, that was another amendment that changed this law. Under the Marriage Equality Act, the spouse now also includes same-sex partners. So a same-sex spouse can be included in the list under spouse. I have 2A, domestic partner, and that's because you can't, under New York State law, legally have both a spouse and a domestic partner. If you're married, you can't have a domestic partner. So if you don't have a spouse, but you have a domestic partner, then the domestic partner would be number 2 on the list. And that's why it's listed as 2A. So again, if the decedent was legally married at the time of their death, the spouse would have priority over anyone claiming to be the domestic partner. If they don't have a spouse, they don't have an agent, then the domestic partner would be the next person you would have if that exists. Any child 18 years or older, you're going to see 18 again all over the place because that's the legal age for being a person under this law. So after that, it's parent, then it's siblings, then it's a legally appointed guardian. Any person entitled to share in the decedent's estate. You see a little asterisk. I'm going to get into that a little bit more as to what that means. 8 is a duly appointed fiduciary of the estate. 9 is a close friend or someone reasonably familiar with the wishes. We'll go into that a little bit more. And the last is a public administrator or anyone willing to act. I will also get into that a little bit more. When it comes to children, stepchildren are not considered children for purposes of 4201. A child to be under this has to be by blood or legally adopted. If you are a stepchild, you are not you do not fall under the list under here of child. Interestingly, also under the law, if you are an adopted child, then the adopted child becomes the child of their adopted parents, but they're no longer the child of their biological parents. So if someone were to come in and say, this was my mom, she gave birth to me, and that person was later adopted and now is the adopted child of some other family, then that person is not able to take control for their biological mother, for example. When it comes to parents under number 4, foster parents are not included on this list either. The foster parent must either legally adopt the child or be appointed guardian under number 6 there in order to have status to control disposition. So a couple of nuances on the list as it relates to those categories. Also, when we talk about a will and an executor, you'll notice on here that the word executor does not appear. You'll also notice on here that the phrase power of attorney does not appear. So those two individuals, by those status of being either an executor or power of attorney, you do not get to control disposition just because you're one of those two. When it comes to an executor is different from a fiduciary legally because an executor is limited to following what is in the will and taking care of things that are specifically in the will. A fiduciary is a much broader term where you're entrusted to do things on behalf of somebody else. Now, that said, it kind of gets gray because an executor can be appointed a fiduciary, but just because somebody comes in and says, I'm the executor under the will, that does not give them the right to control disposition unless they were an appointed fiduciary of the estate under number 8. They could potentially be that person, but it's not automatic. When it comes to power of attorney, this has been one that's gone back and forth, and we've talked to the Bureau at length, and the Bureau at the time when Tom Fuller was director, he went to the Division of Legal Affairs, and as it currently stands, a power of attorney cannot appoint themselves or anyone else an agent. So if you have somebody trying to come in and create an agent form and the power of attorney is going to say, I'm going to appoint myself or somebody else because I have power of attorney over the person, they cannot create an agent form as a power of attorney. That is not possible. And the reason is that the Department of Legal Affairs in the Department of Health has deemed the agent form to be equal to a testamentary instrument like a will. And the only person who can make or amend a testamentary document is the settler or the creator of it. So it's the person who's giving away their money, creating the will, the person making the form. So you are not allowed to step into the shoes of that person through any legal document when it comes to that. So a power of attorney, they themselves have no rights to create an agency relationship on behalf of the person they're acting as power of attorney for. Okay, so now I'm going to jump over to another slide that's going to go into some of those aspects there. So you can see number 7, 9, and 10. So for 7, that one said, any person entitled to share in the decedent's estate. It goes on to say, in the following order. So this list, 1 through 9, is another descending order hierarchy list that would get involved if you get all the way down to 7 and you're now dealing with the decedent's estate and they have people in these categories and they are listed as beneficiaries. You can see how complicated this will start to get. And in this situation, it's a majority. So let's say you have 8 grandkids, you need and they're all 18 or older, then you need 5 of the 8 grandkids to agree in order to control disposition. So getting a majority of these individuals, even locating them all, could start to get more challenging. Probably will require the use of the executor because that's part of their job in administering the will, and or an attorney for the estate if you get down to this one. One of those where you would probably be waiting for direction from a third party. The last 2, where it talks about a close friend, reasonably familiar, or a public administrator, at the end of those, it says, who completes an at-need written statement of person having right to control disposition. So this is different, obviously, from appointing an agent, but those people would have to fill out the at-need form in order to act that way. Obviously, you're usually going and having an at-need form filled out by anybody who's taking responsibility, but the law specifically says in these cases, you would have to have somebody fill out the at-need form in order for them to move forward and controlling disposition. All right, a little further down in that section of law, the law actually gives us a couple of what-if scenarios that we can go through. So I said it's a descending order. If the person is you go down, let's just say you go down the list and you get to siblings, do the siblings have to actually act as the person, the people or person in control? And the answer is no. So you would go to the next in line, the next one down the list, whenever the agent, themselves appointed agent, or the person on the hierarchy list is either unavailable, unwilling, or not competent. Now, the standard for unavailable is reasonableness. So if the person is not reasonably available, meaning you don't have to go hire a private investigator to find them, but you took an effort to find them and you couldn't find them, then that person would be deemed unavailable and you go down the list. Here's an interesting example scenario that we have been posed with several times, and the answer changes based on the circumstances. You've had a situation where a spouse of the decedent is incarcerated, and there were situations where the question was, well, they're in jail, so they can't be available, and therefore I'm going to go down the list. The answer is no, not necessarily. If you know what facility they're in, and somebody can reach out to speak to that person and they're willing to do it and they can communicate via email or phone call, then they would still be available. So it really depends on the circumstances. Again, you don't have to go through great lengths. You have to take reasonable efforts. But if they're not available, you go down the list. Unwilling is pretty self-evident, you're not wanting to do it. And not competent, meaning that person no longer has the facilities and faculties in order to do that. So if any of those situations occur, you go down to either another person on the list with equal priority, so another child, for example, in that case, or if there is nobody else with equal priority, you go down the list to the next person on the list, next numbered in descending order. And that's how you would go through that. When it comes to the duty of agent, person in control, the person who is doing this has a responsibility to carry out the decedent's wishes to the extent lawful and practical. So what does that mean? It means that the person should be looking at different aspects if needed, financial capacity. So if I wanted a $15,000 funeral, I didn't pre-arrange and pre-fund, and I just wrote my wishes down, and my estate only has very limited resources, then obviously you wouldn't be able to carry it out. Those kind of things. You also have to look at the decedent's moral and individual beliefs, and you have by law an obligation as the person in control to carry things out the way that is listed. So again, that responsibility is there for an agent or person in control. This actually has come up in the courts. I'm going to go through and for you real quickly a lawsuit in New York from 2017 where a situation like this came up. So this was in a New York City Supreme Court, which is a lower level court, where the case was this: a woman died, leaving no specific instructions as to how she desired to be buried. She had been divorced twice from her child's father and had purchased a cemetery plot with him decades ago. Her surviving adult children were the legal next of kin and by law, her first in line to control her final disposition. After her former husband's deaths, she, along with her sister, purchased a cemetery plot in her family's home country of Israel. In the years immediately before her death, she continually expressed her desire to be buried in Israel to her sister and her home health aides. While she did not put her exact wishes in writing, she did provide her adult children with the information relating to her newly purchased plot in Israel. The children wanted to bury her in the plot she purchased with her ex-husband that was located in New York City. The woman's sister petitioned the court to override the children's decision to have their mother interred in New York City, arguing that they were knowingly going against what their mother had been telling others. The court then held what's called an evidentiary hearing, where they heard from the children, sister, and health aides. The court ruled that she could be buried in Israel after that hearing. And the reasoning was that the adult children's testimony focused primarily on what they thought their mother would say or do, rather than what she actually said, and as such did not represent personal and direct knowledge about their mother's wishes. The home health aides testified that they had actual conversations with the decedent where she clearly expressed her desire to be buried in Israel. So this law was really very key in reiterating some of the underlying aspects of the Public Health Law 4201. It has the list of people to carry out the wishes, and they said that the children were the next in line. It recognized that. It also recognized that the people in charge have a responsibility to fulfill the loved one's wishes, and that those wishes are paramount to the survivors or next of kin's references, and that anybody who has actual knowledge of the next of kin's explicit wishes has the ability to help ensure that those wishes are carried out, health aides and the sister. And that if you're unwilling, this is the unwilling, right? You're unwilling to carry out the wish of the decedent, you have to go down the hierarchy list to the next person. And then ultimately that you are responsible for faithfully carrying out the directions of the decedent, which clearly wasn't here. So the most important takeaway, and something to always remember, when there is evidence of a family dispute, or if the funeral director has knowledge or reason to believe that the legal next of kin is not acting according to the decedent's written directions or express wishes, you should pause and direct the family to get a court order to direct all how to proceed. That's how you ensure that the legal protections and liability protections that are in the law will actually cover you if situations like that occur. And the last part on this section of the law here, or at least this part of this section, is that it's important to remember that the agent in control is not liable or responsible for paying the funeral expenses simply because you're the agent or person in control. This has come up a couple of times because you have people who say they're going to pay and they want to do things a certain way, but the agent is looking to do it a different way. The agent, the person in control, has the responsibility and the right to determine disposition. Person paying does not have the rights to control, change, dictate the disposition just because they're paying. All right, one more part to section 2 of the law. So can a funeral director basically be the person with the right to control was part of what was being addressed here in this section. So yes, the answer is a funeral director could be the person with the right to control, but if you are playing in that role, you cannot receive any type of compensation or financial benefit for fulfilling that. If you do, then if you're going to, I should say, then you can't be the person with the right to control. The other area of the law that this section covers is orders of protection. So you go down the list, but if somebody is either subject to an order of protection at the time of their death or charged with the homicide, they're automatically disqualified from serving as the person in control. And it does say charged with the decedent's homicide. Again, you might think these things don't come up, but they do. If you are arrested or suspected, it's not enough. So we've had situations where we've been called where someone's been arrested in connection with the person's death by homicide, and they would be the person in control. The family doesn't want them to be, but they still are unless they actually get charged with the crime. And lastly, these prohibitions can be waived by a court if it's deemed in the interest of justice. And ironically, there is a court case from 2020 in New York that dealt with this. So I'm just going to walk you through this one real quickly as well. So in this case, the scenario is as follows. The wife died in 2019, in December, and winds up being cremated. Her ashes were given to her daughter because the wife had an order of protection against her husband at the time of her death. The husband went to the state Supreme Court seeking an order to control the disposition of the ashes of his wife. The husband sued his daughter and the funeral home because the funeral home had given the ashes back to the daughter. And then the court looked at the court documents, and according to that, when you look at the documents, the daughter stated that she had already scattered all of her mother's ashes in Lake George, and then she threw away the container. So the court listened to all parties, and their decision at the end was that the husband was the person declared to be the one who had the right to control the disposition of the remains of his spouse. And they further went on to say that the temporary order of protection that was issued is not an order of protection within the meaning of 4201 of the public health law, as to the point that it would disqualify the husband from controlling the disposition of the remains of his spouse. And that even if it is, a waiver of the disqualification is appropriate in the interest of justice. And then finally, they said, in the event that the ashes of the decedent or the box or container in which the ashes were delivered to the daughter by the funeral home should come into the daughter's possession, she has to immediately deliver that to the husband. So two takeaways for this one is, you notice at the end, the judge said, look, even if this is an order of protection that would bar the husband from being the person in control, I'm going to reverse that in the interest of justice. That was his reasoning. The problematic part is the way the judge clearly was not reading the plain language of the law when he opined that the order of protection issued wasn't one that would disqualify the husband. It really was. And I think that would have been argued on appeal. But again, the card that they play with the interest of justice kind of oversees everything and would allow for this to move on and forward that way. So that are some those are some examples, real life examples for you of how the law comes into play in certain circumstances. The next section of the law deals with the actual appointment of agent form. The law lists the form in the law. So makes it easy for you when you're having someone fill it out, because you know exactly what the wording should be. I'm not going to read the whole thing, but just some highlighted areas that are the most important for purposes of what we're talking about. You can see at the top that the person who's making the appointment of agent is, again, they're saying they're of sound mind, which it goes back to the idea that a POA can't step in their place. But the disposition of their remains shall be controlled by. So there's the specific name of the agent. The special directions allows them to put in specifically what they would like to do, which is important so that if you're doing this, then the agent knows exactly what the expressed wishes are. It goes back to that case between the sister and the daughters and where the person is buried, because had she put in a form like this, or specifically in writing somewhere that she wanted things done, the agent with the daughters in that case would have had to carry those things out. So that gives the person an opportunity to direct to the agent exactly what they would want to have happen. This form does include a question about whether there are pre-need funds available. If you say yes, you name the funeral home. It's just important to note that for purposes of this form, it doesn't mean that the only way this form stays valid is if the funeral home named actually does the funeral services. You can still have the ability, to move funds and use a different funeral home. It doesn't invalidate this form. It clearly just meant to help the agent know where funds are and the funeral director for when the time of that need comes. You can see there, it specifically has the agent information that has to be completed. It allows you to name successors so that if that first person is unable, unwilling, or not competent to serve, instead of starting to go down the list, you can then have other people who would be listed that could step into the shoes of the first agent you named. And then lastly, what am I doing? Hold on 1 second. You can see at the bottom of this slide, it says this appointment becomes effective upon my death. The reason that's important to keep in mind is this form is unlike a power of attorney, because a power of attorney form is only while you're alive and becomes moot when the person dies. Same is true for a healthcare proxy. A healthcare proxy, the proxy is valid while the person's alive, and when they pass, they have no rights to serve in that capacity. The only piece of a healthcare proxy that survives death is any anatomical donations chosen, where the proxy would make sure that those things are carried out. The other thing that you should note about power of attorney, let's say that I appoint, or Kelly appoints me as her agent, and then when the time comes for at need, I am no longer able, I think I am, but I have a power of attorney appointed for me now. The question came up, can my power of attorney step into my shoes and act as the agent? The answer is no. Power of attorney for the agent cannot step into the shoes of the agent and serve in that capacity. So in that case, if I was unable to serve but had a power of attorney, and the person had named a first or second successor, you would start going down the list to see if one of the successors will act as the agent instead. You have, as a person appointing, the ability to change at any time the person you want to be in control and or your wishes as to what your specific instructions might be. So you can simply revoke anything. So if you wanted to do a new form, you simply sign there that you're revoking any prior appointment, and then you sign saying that this is the most current one. The most current will always take precedent. You have to have 2 witnesses who sign this form. A funeral director can be a witness. Again, they can be an agent as long as they're not being paid, but if they're being paid, they can still serve as a witness. And then at the end, there's a signature line for the agent. And this ensures that the agent can't be appointed without both their knowledge and their consent. All right, going down into a couple of other sections of the law. So if you don't have that appointment of agent form, you can rely on a will. But again, as I mentioned earlier, it's got to be very specific about who you're appointing to control your disposition and the manner that you want your disposition to be handled. So what we always go by is, does the will use substantially the same language as the appointment of agent form? If it does, then it's going to be valid and you can rely on it if there's no agent form. If there is an agent form and a will, if the agent form was filled out after the will, it'll be controlling and you would use that instead of the will. Again, the most recent instrument, dated instrument, is the one that's controlling. I mentioned already that the person can revoke one at any time in writing. Now, the way the law reads there, it says that the revocation can be done either through executing a subsequent written instrument, which again, the agent form has that language in there that you're saying I revoke all previous form agreements, or quote unquote, any other subsequent act by the decedent evidencing a specific intent to revoke the prior written instrument. I mean, that's a lot of gray area in there. Any other subsequent act evidencing a specific intent. Is that a text message? Is that written word? It becomes very complicated. So again, anytime you're dealing with something like this and there's a dispute potential dispute amongst the family members, we say stop and tell the family that you need a court order to tell you how to proceed. Otherwise, you're not going to be able to move forward with the protections of the law in place for you. If the decedent spouse or domestic partner is designated, there is an automatic revocation of that designation. So if I'm no longer legally married, I have a divorce or a legal separation from my spouse, then that person is no longer my spouse. If you have a domestic partnership and there's termination of the domestic partnership, then that person was a former domestic partner or a former spouse and no longer has their ability to serve in those roles based on that status. Legal separation is different from I've been separated from my spouse for several years. Legal separation is actually an agreement that the two parties enter into that deals with things like handling minor children, paying expenses and debts, things of that nature. So barring a legal separation agreement, the people are still legally married. All right, so getting to that liability protection I keep referencing. So it's liability protection for both the person in charge / agent and the funeral director. So the person who's coming to you, who says that they are the person in charge, they're protected as representing themselves as that person and disposing of the remains if done in accordance with the law. They're also protected from any liability if they were the ones identifying the deceased person. So they have to act reasonably and in good faith, and then they will be protected from any actions against them for acting as the person in control, as long as they're doing it in accordance with the law and if they were identifying the person. You as a funeral director or your firm acting reasonably and in good faith is protected from liability if you carry out the directions of the decedent set forth in the agent form of the will, or the directions of the person who claims to be the person in control, so long as you get the at-need form that says that they are either the designated agent in a will, or they have no knowledge of anybody else, and they are the person who has the right to control under the priority list. We have created an at-need written statement of agent, an at-need written statement of person form, one if you're the agent, one if you're anybody else on the list. Those forms have been many times endorsed by the Bureau as a very good, reliable form. If you use our forms, you will be protected from liability when you're working with these family members. So we would encourage you to go to our website and grab those forms if you don't have them already. All right. And the last section of the law covers dispute resolution. So disputes regarding who has control of disposition where the persons involved cannot resolve themselves shall be resolved by the court. That's what the law says. We always encourage you to make sure that you are taking advantage of that provision. You as a funeral director cannot be held liable for refusing to provide services if a dispute exists unless you receive or until you receive a court order or a form signed by all parties. The non-court issued form, we would say make sure it has a hold harmless clause. So for example, if two adult children can't agree on a cremation or a burial, but then later come to you and say they agree to bury, get it in writing with a hold harmless clause and have them both sign it. It doesn't have to be an extensive legal document. It can just be very simple. Just make sure it's dated, signed, and basically make sure that they're going to hold you harmless and that it's clear what their decision is moving forward. All right, so we're going to go through a couple of questions and do a quick quiz, and then we'll open it up for some questions. I'm going to show you a question, give you a couple seconds to think about an answer, and then I'll show you the answer. Can a funeral director be appointed the agent? Yes, as I mentioned, they can, but you can't be compensated, or receive any financial benefit if you choose to serve in that role. True or false, the person paying the funeral bill automatically has the right to control the disposition. False. And the person with rights to control is not responsible for paying the bill. Nothing we went over from the sections of the law speak to financial responsibility. On the flip side, a person in control who doesn't pay isn't legally entitled to a copy of the paid invoice either. Just the person who paid is. We had that question all the time. So-and-so was the person in control, X, Y paid, X wants a copy of the bill, Y doesn't want them to have it. We always say, have them work it out between themselves. You have no responsibility to give a copy of the paid invoice to anyone other than the person who paid. Is it possible for a person to be appointed an agent without knowing it? It is not. The law requires that person to accept it in writing, so there's no way they could say they didn't know they were being appointed an agent. Do you need an attorney or notary public when filling out the agent designation form? Nope. You'll notice when we went through that, it did not say anything about a notarized stamp or a notary signing it. The only thing you need are 2 witnesses, and remember, the funeral director can serve as one of them. Is a funeral director responsible for or required to obtain documentation for proof of a domestic partnership? Simple answer, no, not by the law. The individual who's signing the at-need form is going to attest that they have rights to control, saying that they are the domestic partner. Under the law, you can rely on that as long as it's reasonable to do so. So, when it is not reasonable, or when might you want to see documents so that you can prove you acted reasonably, goes back to that same thing. When there's a possible or actual dispute, that's when you're going to want to have those couple of extra T's crossed or I's dotted. Are there any situations when the designated agent or legal next of kin may not have a legal right to control disposition? Yes, there are 2 situations: in order of protection, or you're charged with the homicide of the decedent. Here's a scenario for you. 3 children meet with you to arrange for their father's funeral. 2 wanted cremation, the 3rd does not. What do you do? Do you go by majority rule? Do you refuse to cremate because there's an objection? Do you tell them to go to another funeral home? Or do you wait and tell them to get a court order to determine who has control? So the answer is majority rules, and you can move forward with 2 of the 3. That's the change from 2022. But realistically, if you're uncomfortable or you're concerned about a lawsuit or just a very difficult situation, you can go with 3, and you can always tell them that you need to go somewhere else and that you're not able to help them. That's always something that, as your private business owner, you have the right to do. And the funeral director act as one of the 2 witnesses on the agent designation form. Yes, we've talked about that several times over. Of the following individuals, which one has the highest ranking on the New York State next of kin final disposition list? Fiduciary, public administrator, grandchild, or children, close friend, or relative? This is probably the hardest question that we put out there because these are subcategories. The answer is grandchildren. Grandchildren are on part of number 7, under the list of people who have the right to share in the estate. Then appointed fiduciary was number 8, a close friend or relative is 9, and the public administrator is number 10, the last on the list. True or false, a designated agent can refuse to serve at the time of need. That is true. If you're unwilling, unavailable, or not competent to serve, you go to the next person on the priority list, or the next person in the same category if there is somebody else to go to. Are stepchildren considered children when it comes to the final disposition law? They are not, as we talked about earlier. There's 2 more questions. A couple is separated but not divorced. Is the surviving spouse still the next of kin? Yes. Again, they have to either be legally divorced or there has to be a legal separation agreement in place. So if I just say they just say they're separated, they are still spouses under the law. And lastly, does 4201's priority list only apply when a person dies in New York State? Yes. So it's a state law, so it only deals with New York State deaths. As I mentioned at the onset, the one exception is if the person dies outside, but has an existing valid agent form, New York agent form, or a will that's valid under New York law that has all the conditions to appointing an agent. And in those cases, so long as the disposition is going to happen in New York State, then you can follow the 4201 hierarchy list. All right, so that's everything I have for you. I know Kelly had mentioned earlier that there would be another number. You can see at the bottom right there, the number is 39. And that's everything I had to share with you. So Kelly, if there are any questions, we can definitely try to help folks out and answer some of those.
Yeah, we do have a few questions, mostly things that you did go over, but I love refreshing, and I think these questions were asked prior to you going over them. So the first one is on the priority list, hierarchy number 10. Can an organization act on behalf of the decedent as opposed to a person?
The only case that I know of where that has happened and been approved was a type of fraternal association or a religious association where folks took over. Now, the law doesn't speak to an entity as opposed to a natural person, because if you look at the definition of person, it says persons are natural people over the age of 18, right? So if it says a natural person, 18 or older, and then the list says the following persons in descending order. So legally, if I were interpreting the law, I would say an entity cannot step in. A person representing that entity could step in, but it's got to be a person. And then they'd have to fall into one of the categories. So they could be under 10. It could be anyone willing to act on behalf of the decedent. So if somebody from that organization is willing to act and they sign the at-need form, then sure, they can, but they're not really acting as the entity. They're acting as a person for legal purposes. Hopefully that makes sense.
Okay, the next question is about domestic partnership. Let's say someone comes forward and says they are the domestic partner, but the children are objecting. What do you do? So
if possible, and you can ask them if they have a partnership agreement, or were they registered and do they have a certificate. If they don't have any evidence like that, you can ask them for information to show that evidence of the domestic partnership, like I mentioned before. And then you could show that to the children and say, this is what the law says is a domestic partnership. If they're still arguing and disputing that, I would honestly say you're not the arbiter of deciding whether the evidence they presented when it comes to the totality of the circumstances is sufficient, accurate, anything like that. I would say I'm not going to be able to move forward because now there's it's reasonable to assume that there is a domestic partner based on what was shown. But if you're arguing against it, go get a court to tell us how to move forward and who's in charge.
Okay, so when talking about getting the majority of the children or grandchildren, does it mean we need to have the signatures of each, or just one that is saying they are representing the majority?
Yeah, so the law wasn't very specific about that. So what we did on our forms is we placed signature lines for each of them. So I looked at it as conservatively as possible, and I would want, if there were, say, 3 grandchildren and you needed at least 2 to sign, I would get 2 signatures. The cremation authorization form does it differently. The Division of Cemeteries has chosen to have one person sign saying they are signing on behalf of the majority. Legally, they're protected, but if they accept that form and then someone's like, that person signed and they didn't ask us and we don't agree, you're going to be dealing with a legal battle while they're trying to prove that they did have the authority to sign that form on their behalf, and the others are going to be saying they didn't. And I would not want to be caught in the middle as a crematory or a funeral director or funeral home. So that's why my recommendation is not the law, is my recommendation is get a signature from each individual representing at least the majority of the people in that class.
Okay, if the agent is put on the death certificate as next of kin or informant, does that mean they would be recognized as the next of kin for the cemetery regarding the foundation, monument, and care?
I am not sure how the cemeteries will view that information. I don't think they're required to accept that, but they probably could. But I'm not sure how it works on the cemetery side and how they deal with this with 4201 outside of the cremation authorization form that I just mentioned. I wish I could give you, I don't know the answer. Maybe one of the other funeral directors on the line knows how that works.
Can a legally appointed guardian make the appointment of the agent?
A legally appointed guardian make an appointment of agent. They cannot, because again, the way it was decided by the Department of Legal Affairs, the only person who can do an agent form is the person themselves. As soon as they no longer have the ability to do it themselves, they're no longer of sound mind and body, they can't fill out an agent form. It's only the person, him or herself, who can fill out an agent form. Now, what happens in that case instead is if there's nobody above the guardian who's number 6 on the list, then you drop down to the guardian and they're the person in charge because they're the guardian, but they can't step into the shoes of the person and create an agent who's somebody else or themselves.
Okay, so if a child dies and the parents are divorced, so obviously you can take either parent's wishes, but what if one wants cremation, one wants burial? Would you send it to the court to get a court order?
I mean, conservatively, I would, because again, especially when you're dealing with cremation, you have the legal right to work with either, but when it comes to those situations, we always suggest getting a court order because there's things in the background potentially that you might not be aware of. They're not telling you that might come out in the court that would influence who would ultimately be the one chosen by the court or direct or appointed by the court to be in control. So I would say yes, I would say pause and get a court order. Or again, a non-court order document is one where they ultimately come together and you say, look, you have to go to court and the court has to tell us, and they say, no, we will, that's fine, well, we agree. I would say, get that in writing, that you're holding us harmless from this decision, that you both agree that this is what you want to do, both sign it, date it, and then you have it as evidence.
And along the similar situation, what if there's 2 children, one wants burial, one wants cremation?
Yep, same thing. Follow the same. Whenever you're dealing with people in the same bucket, siblings, children, parents, and you're dealing with 2 and they're split, then I would say get a court order. If it's 3 or more, then you have that new law that makes it easy. You have majority and the minority is kind of left out, but it's very clear in the law. It's clear in the law that you only have to deal with legally with 1 of 2 people in the same category, but too many times it's come up and just dragged out in courts after when someone sues, and they will drag the funeral director and the funeral home into that lawsuit. You're better off waiting and getting a court to tell you what to do. And many times we found from follow-up phone calls from our members that as soon as you say you have to wait for a court order, all of a sudden the party seem to come together and agree on how to go forward. So it kind of sometimes it's just a springboard to resolving the dispute. But if it isn't, then there's something terribly wrong or deep rooted issue, and you're better off letting the court tell you how to go forward.
And we have one last question and a comment. So we have a funeral director that is her mother's agent. as well as her mother's life insurance beneficiary. And her prepaid services are where this woman works. Is that going to be a problem?
It will be. We've had that situation where you weren't the owner, but the firm was making the money, and the Bureau said that that would be problematic, and that if they were going to do it at the firm, then the firm shouldn't be paid for the services. That was the last time we spoke with the Bureau. That was what they told us. And that's why in the slide it actually says the firm or an employee of the firm. So even if you're not the owner, but you're working there, the firm should not get paid.
Okay, and then I have a comment to the question about the cemetery and the, it says the deeded owner should control the monument and foundation.
Okay, that makes sense. So
Um,
the answer to the question would be
that-
no, it's the deeded owner instead, sounds like.
Okay, well, that seems to be the end of the questions. I want to thank you, Mike, for doing this webinar for us. It's always informative, and we get calls like this all the time. Okay, everyone, as Mike has said, you need to pay attention to the number on the screen right now, and it's the 39 number, not the 25 number. And in case we ask, again, allow 7 to 10 business days for your portal to reflect your credit. And I hope you all have a great afternoon and a wonderful Thanksgiving. Thank you so much.